This is three files, 24-6811F8 for perjury, habitual second, 22.5-year maximum. 24-6834FH, larceny by conversion, 5-year maximum. 24-6948, possession intent to deliver methamphetamine, habitual second, 30-year maximum. And OWI second, a 1-year misdemeanor here for sentencing. Counsel, you want to state your appearances, please?
Melissa Goodrich, Boyne County Prosecutor.
Devin Pomeranke, MIDC, Court Appointed Counsel on behalf of the defendant, Mr. Carney, who's sitting to my right.
All right, and have you had a chance to review the pre-sentence report with Mr. Carney?
I have.
Do you have any additions or corrections or modifications to the factual information in those reports?
I do not, Your Honor.
The advisory guidelines were scored at 36 to 88 months for the perjury, 12 to 24 months for the larceny conversion, and 78 to 162 months for the possession intent meth. Do you have any scoring challenges from the defense?
No scoring challenges.
Any scoring challenges or additions, modifications from the people?
No, Your Honor.
Anything you want to say on behalf of your client?
Your Honor, gotten to know Mr. Carney throughout my my short time on his files. I found him to be very pleasant. I found him to be very accepting of his circumstances. And I think this is because Mr. Carney's been incarcerated for quite some time and had a lot of time to think through his decisions. And he's also had the benefit, well, he's done the work, and I think he's seeing the benefits of the programming he's already been able to complete in the Department of Corrections, including advanced substance abuse and domestic prevention programming, which he's already graduated from. Mr. Carney has a criminal history that is no secret to this court, no secret to himself. And this stint of criminal behavior, as well as all of his other, I think are rooted in his drug addiction, Your Honor. And some of it rears its head in ways of trying to get away or keep going with that addiction, or to afford that addiction. And this time really caught up with him and really snowballed. I know that Mr. Carney looks forward to the day he's able to get out, prove to himself, his family, in this community that he can live a sober life. He's got some time to think and work on himself before that. But Your Honor, I don't doubt that with the pressure and the situation that he's in, he'll be able to access the things he can to continue with his understanding of his treatment, his disease, and continue to try to better himself in the situation. I know that he has something to say to this court, that he's prepared as well. But Your Honor, I would ask that the court follow the agreement in this matter, and that you know, Mr. Carney has sat on a substantial amount of dead time. If the court would consider that when it looks to its sentence today, and would potentially consider that consequence in lieu of any consecutive sentencing, or going beyond the agreement as proposed, Your Honor. Thank you.
Thank you, Mr. Pomeranke. Mr. Carney, you don't have to make a statement today. If you don't, I won't hold it against you, but you certainly may make a statement concerning what you said.
I just want to apologize to the courts, community, and my family for my actions. I know what I did is wrong against the law. I take full responsibility for all of it. You know, I thought I could get away with it, and I was wrong. I have a severe addiction problem, and I struggled with drugs my whole life. You know, I do good for 7 years, it seems like, and then I get in all the trouble, and then I do good for 7 years, and I get in all the trouble. It's like a snowball effect. It just takes hold of me. I feel like God was saying enough is enough when I got pulled over that night and called those 2.5 ounces of meth. I was on the way to being dead probably. I was shooting up drugs and needles. Since my incarceration, I've completed ASAT, advanced substance abuse counseling, and DVP, domestic violence program, to better myself and help understand my thinking errors. That drugs don't solve my problems; they just make it worse. Please allow me to be home sooner than later for my children. I understand I gotta suffer the consequences, but I'm worried about kids and my family and everything more than myself right now. You know, understand my decisions got me where I'm at, Your Honor. And I can only blame myself for that. Please know that my goal is to take any time I receive to better myself for the community and my family. With that, that's pretty much all I got, Your Honor.
Thank you, Mr. Kern. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. The defendant is 42 years old. He has 8 felonies and 4 misdemeanors. He's self-employed with a GED education. The defendant has previously served 3 terms of probation, 4 jail sentences, 2 prison terms, with the longest being 4 years, and that was in 2004. His criminal history started when he was 16 years old, and his first adult case right at 18 years old. His recent crime spree looked like it began in 2022, which I believe makes prison here today the only option. He's currently incarcerated on a larceny by conversion out of Presque County. The one here in Sheboygan County was in July of 2023. The restitution was already awarded in a small claims action district court. In December of 2023, he perjured himself in a child custody case in this court regarding his use of methamphetamine. In September of 2024, the defendant had possessed 70 grams after collecting money from 3 other individuals in our community and then tripped to Flint and back. The sentence agreement is not to exceed 99 months. I would ask the court to follow the PSI recommendation for 8 years minimum. Thank you.
Thank you, Mr. Carney. If you please stand for the court sentence. Mr. Carney, I know this may not mean very much to you at all today, but I'm really sad to be here today to impose this sentence. We were, I was involved I was not the presiding judge when you were in the treatment court program in the past, but you were very involved in your child's life when the mother was going through a difficult time and I had suspended her parenting time and you were there for him. And then she graduated a treatment court program, and then you were pretty clearly going through a rough time and I suspended your parenting time, but I was trying very hard to get back to a place where you could be involved in your child's life. And what makes me really sad is that you were clearly struggling and we were giving you many off ramps. And, I know we can't go back in time, but man, if you had just been honest and asked for help, we would have done what we could to help you. And you, I'm not sure why, just persisted in trying to hide it. And it was pretty apparent that people knew what was going on. We just were having a hard time proving it. That's just very regretful to me that somehow we got to this point today. He's you do have a significant prior history, and these are significant charges. The perjury charge doesn't happen very often. And in this case, I think it's a very troubling perjury where we were in a child custody case and a parenting time case talking about how to keep your child safe. And one of the things about that was whether you were abusing drugs or not. And there were some proof issues surrounding that. And then you got to a point where you'd been arrested for operating while intoxicated by meth, had admitted using meth to the officer, and knew that there was a blood test out there. And yet you came to court and under oath, lied under oath that you were not using meth. I don't understand that decision. And it also is perjury at the central heart of what we were doing. We were having a hearing to address your substance use as it impacted the safety of your child. And for a parent to lie about that, in my mind, places that child at risk of harm. So that's a very serious perjury. So I'm glad to see that it was charged and pursued, because people lie in court all the time and we don't excuse it, but certainly if there was a perjury conviction for every time somebody lied in court, we probably have some problems with our dockets, to be completely frank, but that just was beyond the pale. The larceny by conversion, that's consistent with what you had going on in the other county that I sentenced you for. And I think that a lot of it was the drug abuse got a hold of you, so the business that you had got away from you. But then while you got all this going on, you make a drug run downstate, and you're up here with drugs in an amount that are beyond what's going to go into your body, that's going to go, to other people as well. And it was a significant amount for what we tend to see in our community. So I don't know, all that being said, I mean, your attorney did a good job at getting some reductions on the habituals and sentence cap. So I think taking all these things into account, in the 6811 file, the perjury habitual second, there's $130 crime victims assessment, $68 in state cost. And going to follow the recommendation of the Department of Corrections to commit you to the Michigan Department of Corrections for not less than 3 years, nor more than 22.5 years, exercising my discretion to increase the maximum under the habitual statute, and giving you credit for 34 days previously served. That is at the low end of the advisory guidelines, and I believe it is proportionate given the seriousness of the perjury that I have outlined on the record. In file 6834, the larceny by conversion, there's restitution of $3,100.90. Crime victims assessment of $130, $68 in state cost, and it's a 12 to 24 month guideline range. Order that you serve not less than 2 years, nor more than 5 years in the Department of Corrections, with credit for 34 days previously served. It's at the top end of the advisory guidelines. I believe it is proportionate. And in file 6948, the possession intent to deliver methamphetamine habitual second and the OWI second, there's crime victims assessment of $130, court cost of $350, state cost of $118, a fine of $200. And on the OWI, it'll be 34 days jail, credit for 34 days served. On the possession with intent to deliver, it'll be not less than 8 years, which is that's 96 months. Is that right? Yes. Not less than 96 months, nor more than 30 years, exercising my discretion to increase the statutory maximum under the habitual second statute. Give you credit for 34 days previously served. That is a sentence within the advisory guidelines, at less than the halfway point of those guidelines, and slightly under the cap that was negotiated as part of the sentence agreement. So I do believe that it is proportionate to the circumstances of the offense and your prior 8 felony convictions. Although I think there may be discretionary consecutive for one of these, at least. I'm going to follow the sentence agreement for concurrent sentencing. All right, and so Mr. Carney, in all these files, you can appeal if you wish by filing an application to the Court of Appeals. If you wanted a lawyer, I'd give you one, but you'd have to make that request within 6 months of today's date. We're going to hand you a couple copies of your appeal rights in all 3 of these files. Ask you to initial one for us, fill the other one out if you want to take an appeal. Well, good luck to you, Mr. Carney. All right, we're back on the record and we're gonna recall People v. Marianne Burgess, 25-7036. As I understand, the parties have amended the plea agreement, and I have the amended agreement that would dismiss count 2, the no security. Is that right, Ms. Goodrich?
Yes.
And defense has no objection, I presume?
No, thank you.
All right. We'd established a guilty plea to all the other charges. We were in the middle of establishing a factual basis. Okay, so Ms. Burgess, you were operating a vehicle on a public highway in Sheboygan County on May 15th of this year, you'd said. At the time that you were operating that vehicle, did you have a valid driver's license?
No, sir, it was expired.
Before you had operated that vehicle, had you consumed the controlled substance gabapentin?
Yes, sir.
And were you under the influence of that controlled substance at the time of your operation of the vehicle?
Yes, sir.
Did you have some contact with law enforcement?
Yes, sir.
And did you provide them false information about your name or identification?
Yes, sir.
Okay. And were you ended up arrested for the intoxicated driving?
Yes, sir.
Did you know that you had gabapentin on your person?
Yes, sir.
And did the jail tell you, did the law enforcement of the jail tell you to disclose that at some point?
Yes.
And did you fail to disclose that?
Yes, sir.
So you were intending to get that into the jail?
Yes, sir.
Right, you knew that that was illegal contraband in the jail?
Yes, sir.
And were you in the booking area or other areas of the jail with that contraband?
Yes, sir.
And at that time, did you have a previous felony conviction for delivery of marijuana in 2008 out of Pressfield Circuit?
Yes, sir.
And a possession methamphetamine in 2023 in the Sheboygan Circuit Court?
Yes, sir.
Mr. Nightingale, you satisfied with the factual basis?
Hang on, thank you.
Ms. Goodrich?
Yes.
Mr. Nightingale, are you aware of any other promises, threats, or inducements?
None.
Do you believe I've complied with the court rule?
The court has.
Ms. Goodrich, do you agree?
Yes.
All right, Ms. Burgess, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of those offenses. So I do accept your plea. And we'll schedule sentencing, I think, for August 12th at 10:40 a.m. You'll have to cooperate with a pre-sentence report and interview. And Ms. Goodrich, do you have any objection to amending Ms. Burgess's? Are you serving a sentence right now?
I am not, sir.
Okay, you're in on this charge?
Yes, sir.
Any objection to amending bond at this point?
No objection.
Mr. Nightingale, any objection to Ms. Burgess's participation in the review hearings without your presence?
None at all.
All right, so Ms. Burgess, what I'm going to do is amend your bond to a $5,000 personal recognizance bond. It'll be with recovery court conditions. Meaning, once you get released, I want you to reach out to Nicole right away. If you get out during the day today, you come over right now. If it's in the morning, depending on how we get the paperwork out, then come see her tomorrow. And you will, well, actually, if you get out today, come see Nicole and we'll see you in court tomorrow, because part of the recovery court is that we're going to see you once a week in the courtroom to talk about how you're doing. The women come at 9 a.m. every Wednesday morning. Mr. Nightingale won't be here with you for that. We do have a defense attorney on the team, but he's not your lawyer. He's there just to represent sort of that perspective for us on the team. At any time during those review hearings between now and the sentencing, if there's something going on that you don't feel comfortable about without Mr. Nightingale, you just let me know. We'll pull the plug on that until you can talk to him. Okay? Do you have any questions for me about that?
No, sir.
Okay.
Then is our session canceled for tomorrow?
Oh, you know what? Our session is canceled tomorrow, so you won't be here tomorrow. We have a trial tomorrow, so we will not be having recovery court tomorrow. So when you get out from the jail, whether it's today or tomorrow, I want you to immediately come over and talk to Nicole.
Okay.
So she can get you started on the recovery court. Okay.
Okay.